understand how complex employment contracts can be. So I'm going to give as much information as possible, but obviously each situation has its own nuances, and I'm not giving legal advice because I'm not a lawyer, but I'm going to give you some top tips. The legislation is always evolving. So yes, just let me know on the way through if you lose contact or anything. Okay, so the disclaimer is that I'm not a lawyer, nor am I giving you any individual information for you, for your organisation, or any specific scenario. Just a little bit about Harrison's. I think most of the people on the line know me and know Harrison's, but by way of background, Harrison's is a HR consulting firm. These are some of our core services, which are basically consulting, so anything, I suppose, that a HR function would do, but they've decided to outsource it either for capacity or capability. That could be anything from workplace relations, HR, training, development, workplace investigations, psych safety, whatever it might be. So that's our core service for us. Second main service for us is what we call HR team service, which we explain as being our outsourced, insourced HR service. It's very pitched towards a SME business that has like 30 to 300 employees, where they've got the challenges that come with people, culture, HR workforce, and they've decided to outsourced to us. They're normally on a 2-year agreement. We do a HR health check at the beginning. We develop a plan, and then we allocate someone to them as the HR manager to implement that. Then the other services are My HR Experts, which we're about to relaunch. That's an online subscription service full of tools, templates, webinars. So I'm really hoping I'll be able to relaunch that within the month. And then we have recruitment up there, saying that we're not really doing recruitment other than for our consulting or HR team service clients. So a little bit about us. Okay, so I did say in the message that I was going to do top 10, but I really have, it's difficult to get it down to top 10. So I'm doing top 14. So I'm going to go through them really quickly. I'm not going to take questions, given I said I would only go for 15 minutes, but I am more than happy if you want to reach out and to answer any questions to clarify what I've said. Also, just keeping in mind, we have on the call some really strong variances in terms of your experience, in terms of people that aren't in HR, less experienced versus very experienced HR professionals. So I'll try and give everyone something. Okay, so tip number 1 is 90% of employees in Australia, especially when we're dealing in private sector, organisations are covered by modern awards or enterprise agreements. So before we start drafting employment contracts, we really need a good understanding of what that industrial instrument are in most situations, because normally they're covered by multiple industrial instruments, having proper understanding of the classification levels that apply and all of the minimum terms and conditions that sit under there, because we don't need to rewrite that, but definitely understanding that does determine the clauses that we put in an employment contract and how we want to structure that employment relationship, which we'll get into a bit more, but that would be the first point of call. High income threshold I'm going to talk about later on, so I'll just leave that for now. Employment status. So really what you have to have in an employment contract is, are they casual, part-time or full-time? Part-time, full-time sometimes is just normally covered off in the hours of work anyway. But I just have got a point here in terms of employee versus independent contractor. We're not going to talk about it, but you need to make sure they are 2 completely different relationships and therefore require 2 completely different sets of terms and conditions. Maximum versus fixed term. So, we get a bit technical and finicky on this. So just to explain the words is a fixed term contract strictly is you hire me on a 2-year fixed term contract and I'm employed for that time. If you want to, for some reason or need to, get rid of me partway through that, you will have to pay out my full 2-year contract versus a maximum term contract. For example, will go 2 years, but we have a notice period within the contract. So the notice period within the contract therefore allows me to terminate within the contract by only providing that notice period. So generally with clients, we're only ever doing max term contracts. I don't really know any fixed term that we're doing. They exist for a purpose, but we don't we don't have them. So if you don't get that right, there's risks of unfair dismissal and pay out penalties if you're not doing that. So just make sure you've got the wording around that correct. And I should say with either of those, and there's that whole other piece of legislation that's come through of recent times in terms of how many fixed max term contracts you can do. We're not talking about that, but you do need to make sure right at the front of the contract where you've got normally commencement terms is that we also have in that is the actual end date of the contract. And there's also some specific wording to put in there about the contract will finish at that date with or without notice being provided. And we do also mostly reference the reason that it is a fixed term contract, max term, because that helps to support the reason for it rather than you issuing fixed term contracts for not valid reasons. For example, maternity parental leave relief, for example. We have a lot of NFP clients who do have an exemption under some of that max term contract work. So, but we will still put mostly is the reason that position is max term is due to their funding and maybe the piece of funding to link that back to justify that reason. But so that's one part. The other part is we need to have that endpoint and that it will finish on that date with or without notice. Otherwise, there is so much case law that supports as soon as you go over that day, they turn up for work, you've created a new permanent contract. So be very careful about your wording on that. Probation versus qualifying period. So probation period, as we know, we would always normally write 6 months unless we're doing an executive type role. And it's focused from an organisational perspective on is there a performance and fit versus a qualifying period. The qualifying period is under the Fair Work Act and it's the qualifying period for unfair dismissal. So, and some other requirements as well, but 6 months or 12 months for a small business. So, which is why we often match those up. So the qualifying period is 6 months, but they're two different things. In contract, we have 6 months. If you don't have a probation period in a contract, or if you have a 3-month, the qualifying period remains at that 6 months though. So probation period, just the difference between those for understanding. And I also wouldn't do 3 months because the qualifying period is 6 months. So we match them up. And while we're here, I would just say don't extend your probation periods because 6 months is sufficient under Fair Work would consider for you to assess someone's performance, which is why we need probation period reviews in place. Next area, big area, IP confidentiality and restraint, which does vary by position, by organisation, what you're doing. Generally speaking, though, we will always put IP type clauses into contracts. We will definitely always have a confidentiality clause and often very comprehensive. And understanding you might have a policy around confidentiality, but because it is so key, we include it in contract and something quite comprehensive to protect the organisation. But the third area is the restraint of trade. So post-employment restraints. So there is I get often but they don't stand up, so we shouldn't include them. And completely, they will not stand up if you're trying to stop an admin receptionist for going and working for your law firm and they want to go and work for another law firm in the city. That will not stand up. But when it will stand up, and there is plenty of case law around, is if I'm in a GM role or a head of sales role and I go to the competitor and poach all your clients and you lose $1 million in business and we can show that, they will definitely stand up. They do need to show that there was compensation for that. So that can be on entry in employment. But if you introduced a post-employment restraint during employment, you need to show there was some compensation for them to enter in that because it is narrowing their opportunities moving forward. So you need to get them right. The other thing I just have added in here is, and I should say about enforceability as well, the only way, unfortunately, you can really enforce a post-employment restraint, it ends up going to court. So, and in court or through a legal process, you might be able to settle pre-court, but you need to be able to show which is unfortunate for a post-employment restraint to be enforced. You do need to be able to show loss to the business, financial loss normally. So it is reactive in terms of being able to enforce that. But obviously, most of us as HR professionals would normally send out, if we're doing terminations, we would send out the letter that just reminds people of their post-employment restraints. And if we do think they're doing something, then often I know we will work with a lawyer for a lawyer to do a letter to request the ceasing of the whatever it might be. But just to this final clause here is, I think it's an important point, and one that we've recently come across as well, is adding a separate clause around basically a restraint applying to existing employees, because often the post-employment restraint doesn't cover that, and we might not have something specific. So what that is you want to ensure that existing employees also have a specific clause around not poaching, soliciting, whatever it might be, because we've just had a recent client who the employee was actually looking for a job himself, but also soliciting the co-workers to work for this other organisation that he was going to, and soliciting clients from the existing organisation. So we just want that very clear in contract, so we've got something to rely upon. Obviously, in contract, we're going to have remuneration pay rate that differs from obviously we've got hourly rates sometimes with casuals, but then we might have salaries, weekly rates, whatever that might be. We need to address allowances, commissions, bonuses. My advice would be is I would normally not include commissions and bonus structures within contract. We would often have a general term or clause that talks about there may be an entitlement, but we do that as a separate document or program, which allows for regular review and doesn't incorporate it into the contract. So with a whole lot of different terms. You may need to link it to the award if they're award covered. So under the awards, employees are required to know the award they're covered by and their classification levels. So not to say that you need to do that in contract, but you do need to do that. So putting it in contract, you can demonstrate that you've done that. The other way organisations often do it is through a position description as well. Obviously, pay rates are reviewed and adjusted annually. So just some points on that. Doesn't mean you need to change your contracts every year, nor does it mean that you need to have a performance salary review clause that said it will be reviewed every year. We normally write from time to time. And I'll talk a bit more though about that later. Fitness for duty. So definitely some clauses in there about fitness for duty, including psycho fitness for duty as well as that ability for you to require drug testing, which we normally have as a specific clause around drug and alcohol, but also around being able to send them for a medical assessment as a requirement should you have good grounds for that. So deductions. Obviously, again, this is another area that's had a fair amount of, updates to Fair Work plus case law is we need to be careful about employee deductions. So there's some very specific rules about that in terms of in writing and do they need to be to the employee benefit. But I think the important thing is on termination, we cannot be making deductions from statutory entitlements such as leave balances. So just be very careful about that. We do get asked that quite often. And you can't just unilaterally, they haven't returned the laptop, so I'm just going to take $1,000 from their final pay. You cannot do that. But I would still be putting a clause in generally around if those amounts are owing, they will be taken out of the final pay. But they'll be taken out of the final pay not from the statutory entitlement for any wages owing. The same goes, most awards have, if the employee doesn't provide the required notice period, many of the awards have that you can deduct a week of wages. So just be careful what you are deducting if they don't provide notice. Amounts owing, obviously you've got to pay up these other periods as well. But I would say redundancy payments, we don't tend to put redundancy in contracts unless you've got some specific redundancy policy, which again, though, I would keep to policy and not within contract. And garden leave notice periods is just having clauses about the ability in terms of how your notice periods and garden leave work. So you need to cover off on all those scenarios in your notice period area. Obviously, we have to have the work location, job title, and the reporting line. Just the note on the reporting line, we have the position title. We don't have the individual's name because we don't want to have to change it every time the employee changes. So just position titles. Policies, so we will always have a clause that you need to comply with company policies, but importantly is that we don't incorporate policies into contracts. So that just means you need to have clear words about complying and understanding policies, but that these policies do not form part of the employment contract, because many of you have probably seen the cases where companies haven't complied with their own policies, and the employment contract has been found to have been breached. So just be careful about that. I would say the same for position description. So we will write in contracts that, under the performance clause is that you need to, undertake the duties as per any position description, not the position description. We won't say as per the attached. So we refer to it, and we specifically want to say the position description does not form part of the contract as well, because what we want to be able to do is make variations to that position description, and not to be unfair to the employee, but we don't want to have to redo the employment contract and have them sign an employment contract every time we make a change to a position description. We don't want the PD forming part of the employment contract. The same goes for the award. We will say you're covered by this award, but that award does not form part of the contract. Okay, so this is a big area that maybe some of you are using or not. If you're in a completely white-collar professional services environment, such as a law firm, you're probably not using these much, but most of them, if you're in some sort of mixed, blue-collar, white-collar, award coverage type environment, then you would be using some of these clauses. So all awards have a clause around individual flexibility agreements, and they're at about clause 5 or 6, I think. And that clause specifically tells you what you can vary and specifically how you do that. They're not great because they're a bit of a difficult for employees to often understand, and the employer, but we do often use them because it's the only way that we can ensure compliance. The other way of doing that is through an annualised salary clause, but again, not every award has annualised salary clauses. So either way, if we're doing an IFA, there's specific terms that we put into contracts around an IFA, but we need to be careful. The legislation actually talks about you need to enter into employment before you sign an IFA, which I've talked to lawyers a number of times, and the agreement seems to be, which is what we do, we issue an employment contract with an IFA separate to that. They sign the contract first and then the IFA. So what that means, and the advice that we have received is in the actual contract, if we're issuing for a new employee, we include just the base award rate. And then in the IFA, that's where we say, well, your salary's actually 80,000, even though the award is 50,000. But we're going to, in that 80,000 is, it has been calculated to include 5 hours of overtime, annual leave loading, and therefore you're 20,000 better off overall. So that needs to go in there. And annualised salaries are different. The big difference is that you need to monitor that though as well. And you need to do a balance up every year and demonstrate to the employer they are better off overall. Annualised salary clauses go into contract rather than being separate. With both of them, you must meet the boot test, so the better off overall test. So they're better under these arrangements than what they would have been under the same scenario with the award. Casuals. So casuals need their own separate contract because we need to be really clear that it is a casual arrangement. So the pay rate in a contract needs to show the base ordinary rate, what the casual loading amount is, and this is what your rate is. That needs to go into contract and ensure the contract reflects casual, missing an inverted comma there, but that means you don't have notice periods, you don't have probation periods, you don't have leave entitlements other than some of the ones that casuals are entitled to, because we don't want it to be determined as a permanent part-time or full-time contract. So careful on that one. Work from home. So my advice, I think, to risk mitigate as much as possible is we don't include hybrid work from home arrangements within an employment contract. The location is the location because that gives the employer the right to bring people back to work as required. For people that are entitled to a work from home arrangement under the Act, then you would document that separately and that gets reviewed in that way. For hybrid work arrangements, again, you may have a policy around that, but then there's flexibility to change that policy over time. High income earners, my point here is we have high income earners that could be earning 200,000 but that are award covered. So if that is the case for you, my advice is to include a guarantee of annual earnings clause within the employment contract. Because from an employer that gives you certain benefits, such as they won't be entitled to unfair dismissal. So again, there's specific wording that you need around that. So basically, these are the top 14 that we've discussed. Understanding I'm at time. If you need help from Harrison's, we do award and pay audits that are the first part of that. We can draft employment contract templates. I'm going to start doing these HR Bite sessions maybe regularly fortnightly. So there is another one if you want to register for that. My first book, The CEO's Secret Guide to Managing and Motivating Employees, is available via our website. And because we do have a few HR consultants on here, I have also just put up my latest book that's only just out, which is Start and Scale Your HR Business. If that's of interest, you can get through the website that I've got listed there. So that is very quick, the 14 tips on employment contracts. Thank you. So as much as I know everyone needs to go, and I will be stopping the